Defense team for Luigi Mangione now plans to use a psychiatric defense at his state murder trial this fall. Attorneys will argue Mangione experienced an extreme emotional disturbance when he fatally shot United Healthcare Chief Executive Brian Thompson back in December 2024. In a hearing today, a New York judge said that he plans to unseal records tied to an affirmative defense allowed to state criminal defendants charged with murder. It means the accused admits to a charge against them, but criminal liability is lessened due to new evidence presented. The judge ordered Mangione's defense to turn over evidence to support their argument, along with expert names, to prosecutors by tomorrow. Mangione has pleaded not guilty to murder and weapons charges. So let's take a legal deep dive into this case. Criminal defense attorney Josh Colesrud is here. This is interesting, and it's something that you don't hear very often. Explain exactly what a psychiatric defense means and how hard it will be for his attorneys to argue this.
Yeah, it's a very difficult theory to win on. Only 2% of the cases in New York actually succeed once they allege this defense in the courtroom. Now, it's something that we don't hear of very often, a psychiatric defense, extreme emotional disturbance. What is that? Yeah. The equivalent to that in Arizona is, the heat of passion defense, where let's say that a husband comes home and catches his wife with a lover and he, murders everybody.
Right.
That would be a heat of passion defense. Now, in New York, they took that and they expanded it, and they said that if you have a long, festering emotional disturbance over a prolonged period of time, that could also be a heat of passion type of defense. Now, it's not a complete defense like an insanity defense. So if you plead insanity and you win and you prevail, you go to a mental institution for a little while and then you're released. Right. Here, what the defense really is doing is that they're arguing for manslaughter. And they're saying that, he should only face up to 25 years, and that, this was not premeditated, that it was just a prolonged, festering, malfeasance, so to speak.
But, so they're arguing for manslaughter. Is that better than pleading insanity?
Well, manslaughter certainly has a less time that you're facing than the murder charge that he would be facing under an insanity defense.
Right.
So if he pled insanity, he would be facing a life sentence without the possibility of parole. So here they're kind of splitting the baby. They're saying, well, we'll admit to the facts of the case, and if we prevail on this emotional disturbance defense, right, he's only going to face, up to 25 years in prison. Right. But there's a downside because he also has a parallel federal case. And, in that case, they don't have the emotional disturbance defense. And the prosecutors in that case can use all of the evidence that his defense is using in the state case and use against him in the federal case, which is significant because the federal case is predicated on the idea that he was stalking somebody in interstate lines, meaning that he went across state lines and the end result was murder. And the emotional disturbance defense really kind of shows the premeditation that the prosecution needs to show in the federal case. So, in other words, he's cutting his nose to spite his face. You may win the state case, but you're going to give away the federal case if this proceeds.
So bottom line, though, basically, clearly he admitted to doing this, but it's just he wants to get a lesser charge.
Yeah, it's not who did it, it's why he did it.